briefed this issue, we've talked about the case, and so we're very familiar with the issues and facts in the case. You do have a clock on the podium in front of you, so you can keep track of your time. And with that being said, Counsel for Appellant.
Thank you, Your Honors. We don't take this issue lightly. It wasn't our intent to burden the court with such a complicated case. Unfortunately, we were unable, in our opinion, to convince the lower court that the covenant attached to the judgment agreement was actually an illegal agreement. We,
Counsel.
yes, sir.
I don't mean to. I'm sorry. Could you state your name?
My name is James Sullivan,
And you're representing the appellants.
Sunburst Farms, and the intervener, Corinne.
Let me start with a preliminary question. And you might. Why do we have jurisdiction? There's a 54B judgment. What I'm getting at is, I understand there's a 54B judgment that was issued by Judge Gama, right? But, and you can try to correct me on the record on this, but you've got the Holtz bringing, and others bringing this case. Then there's a deck action, I guess I'll call it the Braden litigation.
Yes, sir.
At least as I understand it, there are overlapping issues between the two cases. They're consolidated. There's a ruling that's later vacated in the Braden litigation for lack of indispensable parties, so it's going to basically start all over. But there are still overlapping issues. Why is this a proper 54B judgment?
Because Judge Gama, when we got the favorable result from Judge Swartz, it was Sunburst who had the favorable result and said, Judge, please hold off because, excuse me, there's overlapping issues here, and we don't think it's fair to render a judgment for one party and not the other. We should wait till the entire matter is resolved out of fairness to the parties. Judge Gama, we argued that to him as well, but then he bifurcated the case and rendered the judgment and left us without a judgment in the Swartz case.
What do you mean he bifurcated the case? Did he unconsolidate them?
Well,
Are they still consolidated in the trial court?
there's consolidated but bifurcated, and I always argued, I don't know what that means. You're splitting up, the jurisdiction on us, and it's not our fault. We argued against it all along. We kept saying that these cases should remain consolidated. There should be no judgment until there's a judgment that retires all of the issues. But we were overruled on that, and Judge Gama proceeded to judgment on the Halt matter.
What's the ruling? Where in the record is the ruling? If you have an item number or a date of when he said, I'm bifurcating these two cases, they're no longer consolidated.
It's there. I know it's there. I can look for it when I reserve my time.
Okay,
I will look for that.
About when did that happen?
Right before he rendered the final judgment. Within a month or two before he rendered the final judgment. I'm quite confident, and I think counsel would agree with me on this, that she was arguing that he should go ahead and proceed to judgment. And we were filing motions. Ms. Wilson filed some motions saying you should hold off on the judgment. She kept filing. She filed on a couple of attempts to objections to the form of judgment and rendering a judgment because of this very issue that you now bring. And our arguments were to no avail, and the judgment was entered, and then we were forced to take the appeal.
Well, I understand that. My point is, and I want to make it as clear as I can so that your opposing counsel can address it too, is if the cases are still consolidated and there's overlapping issues, is this a proper Rule 54B judgment?
It is, because these issues have been bifurcated specifically, and the judgment rendered.
Yeah.
So we have no choice but to appeal.
I understand you had no choice but to appeal. I'm not questioning your choice to appeal. Obviously, if I were in your shoes, I'd appeal too. The question is whether we have jurisdiction. and whether we should just dismiss the appeal and send it back down and let everything be ruled on in both cases so that it all comes up one time.
I think you have jurisdiction because of the 54B judgment. I don't think it's necessary to go back down and wait and then come back up on these particular issues because, with all due respect, Judge, the issue as to whether or not the covenant and judgment is illegal or void and should not be enforced is, in our humble opinion, more properly addressed at the Court of Appeals than at the lower court. I felt all along that I was unable to convince the lower court that sometimes mistakes are made by judges, and even though it's been quite some time ago, justice requires that the mistake be remedied. And that was the particular case, in our opinion, here. Additionally, we felt that the form of the judgment, considering the fact that Mr. Castro did not participate in the litigation and that Mr. Lisi did participate and vehemently objected to the Halts being able to collect on his interest in the judgment that was ran pertinent to his lot and a pertinent to Castro's lot, that by Judge Gama granting the Halts to the right to collect on the entirety of the judgment and then forcing subsequent litigation, as he did in his ruling, saying, well, those parties can come and litigate that at the time the money is collected, stripped Sunburst of its defenses because, A, there was no evidence, facts or evidence at all that Lisi wanted to enforce his interest in the judgment. In fact, all the evidence was to the contrary. He specifically came and testified. He participated in the litigation, and he was vehemently saying he did not want to enforce and he did not want the Halts to enforce.
Counsel, let me
Yes,
ask you a
sir.
question. Looking at the record, there was a motion for summary judgment at one point that was litigated regarding renewal of the 1985 judgment.
That was before I was on the case, but yes, sir.
What happened with that?
The court ruled that the judgment did not have to be renewed pursuant to the authority in the Groves case, which we cited in our motion. And we thought it was using the law as a sword and a shield in that, as it turned out, there was no defense to the delay in bringing the new claim for execution on the judgment, but Sunburst Farms' defenses were stripped away by what was termed a delay by Judge Gama. So we felt like, if the judgment doesn't have to be renewed, okay, well then our defenses should still be in play, even the defense of illegality, which Judge Gama really took an issue with and felt like that the delay was not only apparent, but unreasonable. Our position was we should never seek to force litigation, that the defense is properly vested. When a claim was brought or there was a challenge made to a breach of the covenant at that time, the plaintiffs would have to choose or prove that the covenant had been breached, and Sunburst Farms would be availed of all of its defenses.
Right. I need you to slow down just a little bit. Okay?
I'm a little
That's
nervous,
all right. That's
Judge.
fine.
I apologize.
It's just hard sometimes to follow. Getting back to the renewal of the judgment
Yes,
issue.
sir.
So initially, your position was that the Halts had not properly renewed the judgment,
The facts of the case were that it was renewed once,
right?
and then thereafter not renewed.
And then you argued what?
We argued that by not renewing, a couple of things happened. First of all, it made it unenforceable, but secondly, we also Sunburst relied on the fact that it hadn't been renewed as conduct inconsistent with the right to enforce that went to the waiver and estoppel arguments. Additionally, the waiver and estoppel arguments included the fact that the Halts signed the 2004 agreement, which required them to pay assessments to the association.
And that issue is not before this court today. You didn't appeal that issue. The judge's ruling regarding the renewal of the judgment.
We appealed the waiver and estoppel issues, and I think it ties in there. We also argued that out of fairness and justice pursuant to the Rule 60C6 motion that these facts and legal analysis should be considered. I mean, I think this particular case has been troublesome for me because I think the court should not miss the irony of this situation. What's happening here is the one person in the community that never paid a single penny to maintain the infrastructure of the irrigation well and systems, now seeks to take it over and rob the community of a valuable asset. And I just don't think the court can ignore the fact that, you know, there's an interest in justice here that has to be maintained, which is our primary principle as being lawyers and judges, and the mistake was made here.
Let me go back to something you said. Is it my understanding that you're saying that the ruling against your client on the failure to renew the judgment is incorporated into your waiver and estoppel argument on appeal?
I'm saying those facts and some of the arguments are incorporated. Specifically, you know, Judge, if I've been nothing, I want to be able to say I've always been honest with the court.
That's a good thing to do.
Okay?
Good thing
We
to do.
specifically did not appeal the renewal of the judgment issue because, in my opinion, right or wrong, the case law supported the decision. We had many substantive issues to appeal, and in hindsight, you know, I might have even been a little more aggressive on issues than I needed to be. We think the gist of the appeal is the 60C6 and 60C4 motions, which we think were very substantive and rendered the covenant and judgment void and unenforceable on many grounds, including the illegality, and also that the Halls could not, under any circumstances, under the facts of this case or the law, seek to collect the entire amount of the judgment.
Let me try to ask it a different way.
Yes, sir.
Let's assume that we concluded that the covenant, the agreement, the 85 agreement, was not valid.
Yes.
The problem is you then have, but the judge ruled that your Rule 60C motion was untimely to vacate the judgment and therefore allowed them to execute on the judgment. Is there, that sort of raises a conundrum in my mind.
Agreed. And our position,
Okay.
excuse me.
So what I'm trying to get at is the renewal of the judgment, assuming that we found there was no abuse of discretion on the timeliness of the Rule 60 motion, is the renewal issue, which isn't you didn't expressly appeal from, is that somehow before us subsumed in one of the other issues?
Yes. I believe it is, under, again, the argument that in the interest of justice and fairness, this court must consider the extraordinary circumstances of this particular case and render the right verdict finally after all these years. And I don't think under the Rule 60C4 analysis, delay, even unreasonable delay, is not a factor. So there's no delay at all that can prevent this court from rendering the covenant illegal.
Counsel, the rule, all the subsections of Rule 60C state that they have to be brought within a reasonable time.
Well, I cited case law in my brief and at the lower court that specifically said that under the 60C4 analysis, that delay, even unreasonable delay, was not a factor in rendering the proper the proper verdict.
That's only assuming if the judgment is void, right? Not
Right, and we've
not voidable,
Correct.
voidable or ineffective, or I mean, isn't void, Mr. Sullivan, quite a narrow label?
Well, excellent question. I'm running out of time. I want to reserve a little, but I definitely want to answer your question. Narrow, yes, but any of the three elements: lack of jurisdiction, lack of the parties, lack of jurisdiction, lack of subject matter, or lack in authority in the particular judgment given, will work. You don't have to have all three. Any of the three will work. And as we've argued extensively in our motion, we felt like all three were present. The interveners were never adequately represented at the lower court decision back in 1985. the court had no authority in a slander of title claim to endorse a covenant that amended the CC&Rs.
So I understand that. When, if you can tell me precisely or look it up, but when, either in this litigation or in the Braden litigation or both, whatever, when did your clients, when did you assert the specific claim that the 1985 covenant was illegal? Was that raised for the first time in the 60C6 motion, or was it raised before that?
It was pled as an affirmative defense in the original answer. It was not litigated at the trial on partial issues. After we went to deal with the special master and we could not resolve the case and he reopened the litigation, the interveners brought it relatively timely. At that point, we waited a certain amount of time to see if it would be successful. Then the Sunburst itself brought the motion under 60C6 because, as we've argued, they're mutually exclusive.
Okay.
And, Your Honor, again, could you please refresh my recollection? You wanted me to look something up in the record about the bifurcation, is that correct?
Yeah, where in the record that is. Then let me just follow up on one question that Judge Brown said. It sort of was getting, or at least triggered something in my mind. If the judgment's not renewed, is it void?
It could be, Your Honor. I mean, gentlemen, to be perfectly honest with you, you've forgotten more about the law than I would ever know. And I appreciate the opportunity to come and speak to you, but it's difficult for me to instruct this court on the law. I'm just a humble lawyer that feels like that we're in a case that got very complicated where there was an injustice done.
I understand, counsel. And you know, what we're involved in is problem solving. At least that's my view. That we've got a problem before us and we're trying to solve it. And maybe, I'm not saying we're going to do this, but maybe we would want additional briefing on whether one, on jurisdiction, and two, on whether a non-renewed judgment is equivalent to a void judgment.
I understand, sir, and I would remind you that at the time that this amendment, this 2007 amendment was done, as we explained, the documents in the community were a mess. There were several agreements, there were several amendments, there were different sections abiding by different CC&Rs, and this was an attempt to clean all that up for some consistency.
Sure, but that really wasn't, I don't think you were trying to be responsive to my question. I guess I'm saying that perhaps we would be better off with some supplemental briefing.
I understand that, and my response would be I would abide by the court, whatever you direct. Thank you, and I'd like to reserve the remainder of my 2 minutes.
All right, I think we're going to grant additional 5 minutes for each side to argue. So if we can add 5 minutes to each side.
You want, let's see if he wants to use some of that now.
Counsel, I'm sorry. Since we've given you an additional 5 minutes, you now have almost 7.5 minutes. Did you want to use any of that time now, or do you want to save it all for rebuttal?
I would like to just say one more thing, in that on the...
Hold on 1 second. My new clerk over here is adjusting it's very stressful for these bailiffs with me. Okay. Oh, you got an extra second.
Thank you, sir.
Go ahead.
About the bifurcation issue, I believe that Ms. McKetty would probably know the answer to that question because it was her that was pushing to make the cases bifurcated so that she could obtain her judgment. So I just wanted to say that, and I'll continue to look for that in the record, Your Honor.
Before you sit down, let me ask you a question.
Yes, sir.
I suppose an argument here is with respect to the enforceability of the 1985 agreement. Appellees argue that that agreement and the judgment only applies to Sunburst. It doesn't apply to any of the homeowners in the association, or any homeowners for that matter. So they're free to go and amend as the CC&Rs permit. So it's not an unenforceable agreement to the extent it binds the hands of all homeowners from amending pursuant to the CC&Rs. What do you say to that argument?
Well, their argument is that the homeowners can freely amend. They can freely amend if they pay the $350,000. Now, I don't think having to pay $350,000 is a free amendment.
I'm not sure that's what they're saying. They're saying that that $350,000 judgment doesn't apply to them. They wouldn't be in breach of the covenant if they amended the CC&Rs. Only your client is in breach if your client.
And my client is a nonprofit organization that has no source of income. It's not a business. It relies on the homeowners to fund it. So, in reality,
why would your client have to have anything to do with the amendment? Why couldn't 200 plus homeowners, whatever, sign the amendment, walk it to the county, and file it? How would that trigger a violation of the covenant?
Well, practically speaking, which homeowner would do that?
Somebody that cared a lot.
Somebody that wanted to assume the liability of dealing with these people in this community that's been going on for...
I mean, what we're getting at is that it's a very narrowly structured covenant.
I don't think it is narrowly structured at all, with all due respect, Your Honor. It says any document filed or attempted to be filed that requires any homeowner, not just us, any homeowner to either A, pay any fees, or B, be a member of any association. I disagree that that's narrowly tailored.
Filed by whom?
I'm sorry?
Any document filed by whom? The agreement is between whom?
The agreement is between Sunburst Farms and the predecessors to the Halts.
The association, in essence.
Correct.
And so it's broad in that sense because am I right that because the only way the association can amend the CC&Rs to require membership is through a vote of the membership?
Correct.
Like a corporation that maybe the board could take certain action and act for the association. The original agreement didn't say the board can't do this. It said the association can't do this. Is that right?
Yes, sir.
Okay.
And getting back to the importance of the intervener's motion, the homeowners, their property rights were affected by this. And that gets back to the three elements in the 60C4 motion, which we believe are substantial, and that without a doubt, their right to freely amend was affected, because now that free amendment costs $350,000 that, they have to pay eventually to retain the assets in some way, form, or another. If I may retain the remainder of my time.
Yes.
Thank you, Your Honors.
All right. Counsel for Applee.
Good morning, Your Honors. My name is Melanie McKetty. I represent in this proceeding Robert and Lynn Halt. I think I'd like to start by clearing up some of these issues in the record. I am the one that pushed for bifurcation, and for good reason. I pushed for bifurcation, and it was granted back in 2008. And it was granted and reaffirmed by just about every judge or special master that looked at this case.
Back up. Who pushed for consolidation?
That would be the Sunburst Farms. Yes.
What
happened?
And you objected to consolidation?
I sure did, and I think that objection was founded, but by this point, having all the parties in the same place, I think it makes sense that we've gotten so far out of where we started. I am now at the position where the objection of the consolidation, I guess it's been rendered moot at this point. But the reason there was no need for consolidation and that it never should have happened and we ended up with a kind of roundabout and bifurcation is because these are separate issues.
What record item in the record are you referring to when you say the court bifurcated?
Your Honor, I don't have the index of record before me, but around 129 was the motion for consolidation. Shortly thereafter, you have a May 18th, 2008 ruling, and that was by Judge Heilman. His second judge to take the case right after Judge Miles. And Judge Heilman, I believe, I'm very close to quoting here, said at the argument after trying to understand what's going on here, because at first glance it's very confusing. And he said, oh, I think I know what Judge Miles was doing here. I know why he set it for trial so quick in October, which was a few months away at that point, because these issues really don't have anything to do with one another, and I can explain exactly how that's the case. If you have amendments to the CCNRs that constitute a breach of that agreement in 1985. Whether or not those amendments are valid has nothing to do with whether or not the breach is enforceable. They could have recorded perfectly valid amendments, nothing wrong with the recordation whatsoever. Yet you would still have a breach of that agreement in 1985.
But counsel, I sort of understand where you're going, but you're starting to lose me a little bit. My question was, you moved, for want of a better word, to bifurcate. And my question was, what judge and when did bifurcated it? So we could take actually, rather than just saying, oh gee, you know, it was sort of bifurcated or it wasn't bifurcated, and what does bifurcation mean? We could actually look to see what the court did.
Yes, Your Honor.
And I'm wondering if you could refer me to a specific order in the record besides, and without getting into any detail, just tell me what judge did it and about what date.
Judge Heilman, May 2008.
Okay.
I
And
believe
then
May
why,
19th.
and why in 2010? Now let me get to the next step of this. As I understood what you were saying is, oh, I understand what's going on. The judge said, I understand what's going on. These other issues aren't related. Why then in 2010 did Judge Schwartz issue a minute entry on November 10th that said, the following is a list of the issues yet to be decided, among almost all of which relate to the enforcement claim. And one of them was whether the 85 judgment was, whether the 85 settlement agreement is invalid.
Because that was an issue that still remains pending, despite the fact that we had a trial on this case, the 85 enforcement case in 2008, October. Motions were filed after the trial date. Motion after motion after motion. And one of those motions, I believe Judge Short was looking at, the motion filed the association in June 2010 regarding the validity of the CCNRs and the 85 judgment. There was an intervener motion directly filed affecting the 85 judgment, and then again a motion directly filed by the association on the 85 judgment. Throughout the trial, these were treated separately. We were either talking about validity of the 2007 CCNRs, or we were talking about enforceability of the 85 judgment. So it never got to where those two issues were intertwined, other than listing in these whole case before the court, pending issues exist. This one's on 85, this one's on 2007. They were never mixed because they don't relate. They only involve the same parties, and the underlying facts definitely relate, because the act of recording the 2007 is what breached the 85 agreement.
But does I'm going to call it the Braden action, which is a declaratory judgment action, doesn't that challenge the 85 agreement? The validity?
Your Honor.
I thought that was a specific allegation in the complaint.
No, Your Honor. The complaint filed by Sunburst was a declaratory judgment seeking to validate the 2007 CCNRs filed by Sunburst in 2007. There are allegations made in the counterclaim and in the answer to our complaint that the 85 judgment was invalid and the 2004 settlement agreement.
So you're saying in the Braden action, fair enough, the deck action,
Yes.
you're saying there's no allegation in the complaint that the 85 agreement is invalid?
I believe the association's complaint concerned only the validity of its 2007 CCNRs.
Well, I have to correct you on that, counsel. I'm reading paragraph 28. It says the 1985 Board for Sunburst acted improperly in entering into the settlement agreement and covenant not to execute, which makes the 1985 settlement agreement and covenant not to execute invalid.
And that was the complaint and not part of an answer. I'm so sorry, I don't have it in front of me.
That's
You may
the-
very well be
That's
correct.
the complaint, the 2008. I mean, where we're going, I mean, what the court is concerned about is that there are and continue to be overlapping issues between the two cases.
I understand that, but that's why I was trying to explain how we got to bifurcation and how every judge that after Judge Heilman in 2008 bifurcated, how all the other judges agreed with that bifurcation is because you can have the one result without the other. We could, for instance, we could have no breach of the 85 agreement. And as your honors pointed out, that would be if the homeowners are the ones that did the amendment at issue. That's what happened in the Duffy case that was published in 1979. That shows you exactly how the homeowners can take it upon themselves and amend these CCNRs. And then, in fact, that was
And do
against the
what?
court.
And not form a new homeowners association? Just run it by themselves with no
No, there
with
was
no funding?
there were CCNRs in place, and the homeowners, without the help or work of the corporation, took it upon themselves to amend CCNRs. And what they
To
did-
amend them, but how do you operate it as a practical matter? How do you
It was
operate?
operated by the corporation, bound to do so by those CCNRs. The corporation
Let's
is.
let's say they did what you're suggesting, and they formed a brand-new corporation, Corporation ABC.
I'm not
Would
suggesting.
would that be a successor in interest to Sunburst?
Your
I
Honor,
think
I'm
you'd probably
sorry.
argue it would be.
I'm not suggesting
Yeah.
that, and actually, interestingly, we do have a successor entity here, because the original entity is SFEM Water, and it's the one that holds
I
the well.
understand that. I'm talking about what you're suggesting is that the homeowners, I agree, I tend to agree that the homeowners could go out and physically get the signatures, but it doesn't, I don't know if the amendment even paragraph even talks about signatures. It talks about votes, I think. I don't know if that
The
means
amendment paragraph.
signatures, but let's say that they do. And then let's say they carry physically, they go record it. So the association has done nothing. But let's say that creates a mechanism, a new homeowners association. Is that a successor in interest to Sunburst Farms?
Your Honor, I would have to see that amendment at issue, but what I can tell you what happened in Duffy is the homeowners said, we are changing this community from a mandatory homeowners association to an optional water company situation. This community from 1979 forward, and the Duffy court agreed, was the homeowners all by themselves, took it upon themselves to delete provisions of the CCNRs that said this is mandatory membership. That's what they did there. So, and if you look at the language of the CCNRs, the first amended CCNRs, which we contend are the only valid CCNRs in this community, it is the Homeowners Act and only the Homeowners Act, and why this corporation should be involved is only because the homeowners elect representatives to act as the corporation and sit as a board.
The 85 agreements with the association, right?
Only as a corporation, absolutely.
How can the
How could the corporation bind the lot owners if you just said that all the power and authority for this subdivision comes from the lot owners?
I don't believe it did, Your Honor, and I don't believe it could, and that is why I have said throughout this case that there was nothing done to the CCNRs, there was nothing done to the property rights, there was nothing done other than by a promise by a corporation not to itself take an action against these people that were the other parties to the contract. That is the only thing that was done in 1985. Corporations are free to enter into agreements, they can sue and be sued, contract and contracts without involving their members. It happens all the time.
they
And in
can't
fact,
they can't amend the CCNRs without involving their members.
that's correct.
So if the membership decided to amend the CCNRs, you're saying they're free to do that and there's no penalty. The agreement does not bind the members. It only binds the corporation.
Correct. If
You
this
sure?
would have been,
So you're saying that.
I am. If this would have been a case when Sunburst Farms Corporation went out and had nothing to do with it, only homeowners, A through Z or whoever, got out and signed the petitions and recorded the documents, my clients wouldn't have a case to enforce the judgment. It wouldn't have been that party, the only party at issue that promised, I'm not going to do this again. I, the legal entity, Sunburst Farms, I'm not going to record this type of document ever again because I've put you guys through litigation twice at this point, and now we're at round 4. And so that is exactly true. If it was just the homeowners, we wouldn't be here today. I suspect they'd be fighting over the validity, which is the separate case that's still pending, but we would not be fighting over that judgment because, no, it would not be enforceable.
Counsel, let me ask you this. In looking at the 1985 agreement, let's say that this scenario plays out, that separate and apart from the homeowners association, the homeowners go out, they come up with the amendment, they pass the amendment, they record the amendment, all the action is taken by the homeowners. And then when all that's done, the homeowners association, Sunburst, says, okay, we'll adopt those CCNRs. Has Sunburst then violated the 1985 agreement by adopting those CCNRs?
Sunburst would have had to have been the party to go out and record the document, and Sunburst doesn't have to do that.
Right. And if it doesn't do any of those things, but then adopts the CCNRs and then enforces them at the will of the homeowners, they're not in violation of this 1985 agreement.
They would not be. They would have to take the act of recording the document And the amendment process does not require the corporation to record the document.
So you're saying that if the association membership amended it, recorded it, and the board then sought to enforce it against your clients, the board would be free to enforce it against your clients without any penalty?
I agree. I don't believe anything in the language of our 85 agreement talked about enforcement. It spoke only of you cannot, you being this entity, take this action and you cannot record a document requiring us to pay fees against our consent. Now, if the homeowners amended like they did in the Duffy case, all by themselves, no company involved, they did the recording, they did the amendment, and in fact, the company itself was opposed, and that's who sued them and got them all the way up to that Duffy case. So it's possible, and it happens, and it's how a lot of communities operate. My clients wouldn't have any action with relating to the judgment, and we know there's cases have existed where they haven't enforced the judgment, such as the 2004 litigation. It wasn't enforceable because this company didn't record anything. So my clients did not enforce the judgment. Did they take the same kind of action at issue that was a problem to my clients? Yes. Did litigation ensue? Yes. But did my clients say, I'm going to get you with this judgment? Well, no, because it wasn't triggered. It was a different kind of action altogether.
I'd like to turn to the illegality defense, if you will, of the 1985 agreement. We just pointed out it was, or opposing counsel said it was raised in the answer as well, and also in the complaint. But from your point of view, what's so concerning, or what was the crux of the Rule 60C6 motion that was so, and that was new, that you had never heard before? Say, we've never heard this argument before. Can you explain to me precisely what those arguments were?
Sure, Your Honor, in the answer, it was an illegal restraint on alienation and an illegal penalty. Those were the issues brought before trial, and that was October 2008. After the fact, and going all the way through, I believe the last motions were filed somewhere in late 2011, we had a motion that said it was void upon its face by the interveners, and I note that the only intervener out of the 40 is one appealing, and she's also a board member, and she's here appealing that ruling. She's the only one that possibly can, because they were the only ones that could possibly bring that motion. The Sunburst Farms Corporation can't bring the motion against itself saying it entered into a valid ruling. Now that aside, 60C4, the judgment is void ruling, was when we got something entirely new. And then when that didn't work, we went to 60C6. Now my understanding of 60C is that if 1 through 5 apply, number 6 doesn't. But that issue aside, we've responded to both. But in 60C6, the original motion looked to me to be a repeat of the 60C4. And I said, here we are again saying the judgment is void.
You said it was in the answer.
In the answer, they said void as an illegal restraint on alienation and as a penalty. They did not say 60C.
Well,
But how do you
obviously,
address the complaint? I mean, that it was in 2008 that they put your client on notice that they were seeking to have it declared invalid.
They did, and they argued in a different manner. They didn't raise Rule 60C at all. They didn't raise any of those issues. They just said as an illegal restraint on alienation and a penalty, because there's a penalty for the amount of the judgment. Now, as soon as they phrased it as Rule 60C, we responded appropriately, but at each place, the argument was essentially the same in any event. You can't do a collateral attack. You can only do a timely direct attack. A Rule 60C, anything but 4, is a direct attack.
was the issue of the illegality, putting aside the Rule 60C language, the issue raised in the answer as far as the invalidity of the agreement, was that ever tried to the court?
Tried, no. Resolved through summary judgment.
That's
Yes.
including that. So it was resolved through summary judgment.
Yes. And it was reviewed numerous times. So what we have here, Your Honor, is very important for me to point out. My client never sought a new judgment. My client sought to add a successor company to an existing judgment. My client took out execution on that judgment before doing any of that. And what we had here, due to their own issues within themselves, the company that owns the well is lapsed and is a non-existent entity today, yet it still owns real property. 10 years later, some other people came along and said, I'm the successor, and formed a new entity. And they did it, and we're agreeing, you're the successor, fine. So what we did is said, if you're the successor to the entity we have that judgment against, then you're going to be added on as a party. Because if you're a successor, you succeed to the liabilities. We didn't seek anything new.
Counsel, can I ask you a couple questions? First, is it your position that Sunburst, under the 1985 agreement, is prohibited from amending the CCNRs?
No. They can amend in any way, and that kind of goes to your Dreamland decision, but they can amend in any way that's foreseeable by the CCNRs, and as so long as it doesn't impact directly what that specific language says. And that specific language of the 85 agreement, and they can. They would just have to pay under their judgment.
Because I'm looking at the agreement, and I may be reading it too narrowly, but all it says is that they are prohibited from filing
Correct.
CCNRs. So,
Filing of a certain kind, and if they do, they have to pay the judgment. Not that they can never ever do this, or they might, I don't know, explode or something. They can take this action.
what if
They would
somebody
just
else
have to
files
pay.
it?
If someone else files it, we don't have any action on our judgment. And that's what happened in 2003. Nothing was filed, but they tried to enforce mandatory membership.
So the
there was
scope
a
of the
dispute.
agreement is any other homeowner, any other group of homeowners, they can amend these CCNRs. Sunburst can be involved in amending the CCNRs. In fact, Sunburst can even have a meeting to amend the CCNRs. The only thing they can't do is Sunburst can't personally and physically, through the board, I would assume, file those amended CCNRs.
That's the way I read
That's the
that
scope of
agreement.
it? Okay.
I read that just like that, Your Honor. And I think it shows to heart why we didn't take action on the judgment in 2003. Because that event, that very, very specific event, even though they were enforcing mandatory membership, mandatory assessments, they didn't do it in the way that triggered that judgment. They didn't file anything.
Okay, I understand. Now,
So-
you heard us ask some questions earlier about renewal of the judgment.
Yes.
Has this been litigated in the case?
Yes, it was resolved through cross summary judgment motions, Your Honor, and it was resolved very early on, I believe, April 2008 by Judge Miles. The law existing basically provides that when you have a judgment and a covenant not to execute, which are fairly common in more like a debtor-creditor arrangement, you owe me a debt, you're going to take X years to pay it off, so I'm going to have this judgment, but I'm not going to do anything with it so long as you're honoring my agreement. We do this all the time, Your Honor. And during those times, the law says I don't have an affirmative obligation to go out and keep recording this judgment so long as you're performing. If you're not performing, I have to take action on the judgment. There's no affirmative obligation on me to keep recording the judgment. The idea is that the interest keeps running because that's what it says.
Let put aside the interest for a second.
But there's
What's your authority? What is your best case that says if I've got a judgment that incorporates a covenant not to execute, I don't have to renew that judgment to execute on the covenant, on the covenant?
The Groves versus Source, I think, would be my best case, but there are additional cases and some secondary authorities, such as the Corpus Juris Secundum sections we provided in our briefs. And it's all consistent, and we've never found anything to the contrary. That obligation is not upon us when we're all performing. And we did perform this agreement.
Is a judgment that's not renewed a void judgment?
No, and that's a great question, because there would still be jurisdiction. The only question to ask about whether there's a void judgment is you have to look at the judgment on its face, and our cases are 100% in a line. Did the court at the time have jurisdiction over the parties, jurisdiction over the subject matter, and the power to render that particular judgment? And I don't believe any of us dispute that is the law on what we're evaluating when judgment is void on its face.
Counsel, when we asked opposing counsel whether that issue was before us or not, he argued that it was, in the sense that the waiver and estoppel issue that's related to the renewal of the judgment was before us. Do you agree or disagree with that?
I completely disagree. There was an express ruling in April 2008 that said that we did not have to renew the judgment. If they wish to appeal that ruling, they should have. They identified every other ruling that they appealed. Now, that said, what referring to is the tolling of interest argument. And basically, that argument concedes that interest, or we didn't have to renew, excuse me. And they're saying because of that, conceding that, well, then I shouldn't have to have interest run. And I think we briefed that at length in our briefs, but that is the only way this renewal stuff ties in, and it's an admission that, well, they didn't have to renew, therefore interest shouldn't run against me. But as far as waiver and estoppel, it has nothing to do with renewal at all. It has something to do with the 2004 settlement agreement, and whether my client's act of entering into that agreement waived any rights of enforcement.
Counsel, I'd like to go back to a comment you made a couple minutes ago that said you weren't seeking a new judgment. Well, I mean, technically, you obtained a new judgment, I mean, because you had to add a new party onto it. And also, weren't you specifically seeking a determination from the court that there had been a breach of the 1985 covenant?
Necessarily.
Wasn't that necessarily included in your complaint?
In the complaint, because there was a successor entity, that became an issue. However, had there not been a successor entity, it would have been an execution action, and that's how this started.
Well, if they had come in to seek an injunction to prohibit, then I suppose you would, one way or another, you would have ended up in litigation to determine the merits of whether there was a breach, correct?
Yes, and whether there was a breach, of course, technically it was an issue, but really it was never disputed. I guess in a roundabout way, but nobody ever took that part of the disputed issue. They recorded the documents. They did the filing. According to that agreement, there was a breach.
So what's your best authority to say that you get interest? I mean, have you come across any case similar to where there was a covenant not to execute, and in fact interest was back to any Arizona case?
In all honesty, have I come across a case? No. What I have come across is a case that says you enforce the judgment as it is written. And the judgment is written, says interest runs from the date of entry on its face.
Even if it's 100 years, doesn't matter.
Well, yes, and that's the purpose of finality of judgments, and that's the purpose of having contract reliance.
Purpose of renewing judgment is to make sure they're still viable and executable.
Well, and we do have performance going on, though, Your Honor. And we have people moving in and out of this community relying on the existence of these documents. So that's the same respect. The obligation to renew is completely independent.
Aren't people entitled to rely on our statutes that say you must collect on a judgment within 5 years?
I understand the court's point, but at that point, the case law says if you have a covenant not to execute, because that's the consideration here, we have the judgment. We could have collected right at that time, but we had a big concession on our part saying we're not going to collect against you, we're not going to pursue our other claims.
Assuming, that all assumes that the covenant itself, the agreement, settlement agreement was valid.
Yes, and I also say that isn't before the court today, because that is a contract. And what we have before the court is whether the judgment is void on its face. And that language, on its face, means we don't look at anything else. Otherwise, it would say under the circumstances or in consideration.
Is that issue still going to be determined in the Braden litigation?
No. I believe the validity of the 2005 or 1985 agreement is done and over with. It is far too late to attack the validity of a contract entered into that long ago. You're looking at the judgment and enforceability, and the only available argument left that doesn't have a time limit is void. And, Your Honors, I believe it's the end of my time, but the void is void on its face.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. I would like to address a couple of the issues. Judge Brown, I think you're absolutely correct. They did and have to seek a new judgment. They sued for a new judgment. They absolutely had to prove that the covenant was breached. So it really was a dual issue in that first they had to prove that the covenant was breached.
Okay, but
to
then
enforce.
how does that help you?
Well,
On what issue? On what particular issue? On the interest, or what is that?
it helps us on the interest. It helps us in the form of the judgment. And it helps us on the timeliness of these Rule 60 motions. At that time, everything becomes in play. Sunburst is availed all of its defenses, including illegality. And in this particular case, in our opinion, there's no doubt in our mind that that covenant is actioned by 3 property owners with the board that alters, extends, or tries to revoke the existing restrictions. And it affects every homeowner in that subdivision, all 280 of them. But only 3 can enforce, and then when it comes time to, when it hits the fan, only 1 tries to enforce, 1 doesn't show up, 1 comes and says he doesn't want to enforce, and here's where we are. Now, how can we say this is not affecting everyone in the community? It is. in our opinion, the Rule 60C4 motion is valid substantively as well as the 60C6 motion, but I will remind this court of the cite from the Roll v. Janica, where the court said even though 60C4 and 60C6 are mutually exclusive, in that particular case, they said that the judgment could have been rendered null and void under either analysis, and we think that's the case here. We think under either analysis, it's an illegal agreement, and the passage of time can never render an illegal agreement legal.
Was the validity of the 1985 agreement ruled on by the court? Besides the Rule 60C, was it ruled on by the court?
The which motion, Judge? Well, actually, both were. So the answer would be yes.
The validity of the 1985 agreement, was it ruled upon by the court, and so that it's properly before us?
Yes.
And where was it ruled upon by the court?
What happened was Judge Shade made, Special Master Shade made recommendations. There was confusion because Judge Heilman had adopted conclusions of fact and the findings of fact and conclusions of law, but issues were clearly still being litigated which were inconsistent with those findings. Special Master Shade made recommendations, but Judge Heilman didn't necessarily adopt all of those. He just kind of left it open, and then he retired from the bench. I guess he became sick or something. Judge Gama got the case, and by that time, the 60C4 motion was in play with Special Master Shade, who we thought misapplied the law, where he said it made it potentially expensive to amend the CC&Rs, but it didn't prohibit it.
Right, but my question was,
Judge Gama.
is the validity, did a judge rule on the validity of the 85 agreement? And if he did, where did he do it?
Judge Gama ruled on the validity by, in his minute entry, where he denied our motion and eventually granted Halt's judgment over our objections to the validity of the agreement. So in fact, he did validate the agreement, although on 60C4 he validated it, 60C6 on procedural grounds.
Thank you.
Thank you, sir.
All right, thank you, counsel, for your arguments, your briefs. We'll take this matter under advisement, and we'll issue a written decision in due course. Court's in recess.